we've just been talking about environmental damage, and that will contribute to the estimation of the damage at sea. There are, in fact, a number of international provisions, and this system is very interesting because it's counterbalanced by a liability limit. Cedre has observer status with the IOPC funds, and that is why we invited Thomas Liebert from the IOPC funds to be with us today to present the question of environmental damage and the economic assessment of those damages. So I'll pass over to Thomas, who is in charge of external relations, who will be presenting the international compensation mechanism. Thank you.
Thank you for inviting IOPC Fund to take part in today's Information Day. I wasn't able to be present throughout the day because there were some meetings with member states that are being held today and tomorrow. So I was kind of between two screens, but I was able to hear quite a bit. And I would like to, in fact, make a presentation that's basically in two parts. As you said, it's, you mentioned it's an international dimension, it's an international scheme or regime. And I'll tell you about it and then go into more specifics about claims for damages, etc. So this gives you a general overview. Let's move on to the next screen. What's clear is that system in the case of oil spills or other spills or accidents includes conventions which cover compensation for potential victims caused by accidents. So in terms of international regimes, there are several. The first is that of persistent oil, and that can be cargo oil or bunker oil. And then there was convention which created, in fact, the IOPC. That was the first. In fact, that is the older of the regimes because it was created in 1969, and then the IOPC in 1971. And since 1978, they have basically functioned together. So I talked about persistent oil, and then for dating back to 2001, there was one on bunker oil. And this involves pollution caused by products, hydrocarbons, oil or whatever, transported in the bunker. And these are also persistent. Sorry, I speak English so much in my job that sometimes I can't find my word in French. So this bunker oil convention covers potential damage caused by bunker oil, whatever the vessel in question. Then a more recent one from 2007, but only in effect since 2015. It's not so much on products as the damage or problems caused by wrecks and wreck removal. Sometimes questions of recovering products that these vessels were carrying. And finally, chemical products. It's not yet in effect or in force. It was modified in 2010. And this is an important one because it's the last of the conventions concerning civil liability at sea. So that gives you a very general overview of the situation, but basically we have these two compensation funds for oil pollution, the 1992 fund, CLC, and the CLC Supplementary Fund. So there's a creation of an intergovernmental organization which was created initially in the first version. The convention was actually reviewed and revised. The idea of the convention and organization is to pay compensation for damage caused by oil, hydrocarbons, by tankers carrying persistent oil, for example. And they were used to recover compensation. And when you look at the map, there are numerous states and countries which are members of it. In gold, you see members of the Supplementary Fund. In green, it's the 1992 fund. And then the other figures you see, green and gray. The idea is to ensure that all claimants receive equal treatment and that there wouldn't be any preferential treatment being applied. And this carries on from the previous slide when we look at compensation, the idea of providing compensation to victims of pollution damage. There's a request to open a file. You file a claim, actually, as for any form of insurance. And then it's examined. We see whether the claim is acceptable or not. And it can be through out-of-court settlements. There's no particular reason or no requirement of going through the courts. So it can be amicable or out-of-court settlement as well. Now, as concerns tankers, these oil tanks, sometimes there's confusion for the different types of oil spills, but this covers pollution damage which is caused by spills of persistent oil from oil tankers. And it applies to specific territorial waters, and the EEZ zone, or the equivalent of the member states. When we look to be a little clearer on this, we're talking about two conventions which actually work hand in hand, but they are distinct. So you look at the CLC, which is the first tier, if you like, and that means that when you sail ships, your responsibility is to take out insurance, and this civil liability convention means that when there is a problem, the ship owner may have to pay, but he also has insurance, pays an insurance premium, which would give him coverage to a certain extent. If it so happens that the ship owner's funds are not sufficient to cover the severity of the accident and the effects, then the 1992 fund, according to the convention, takes over, and that fund is supplemented by or fed by the oil receivers. So they contribute to reimbursing the cost incurred and the damage caused to individuals. And then there was an additional financial amount with another fund managed by the 1992 fund, but the Supplementary Fund, which applies and is managed by a number of countries. France is one of them. And now it's a smaller group of member states, 114 states for the 1992 fund and 30 states or countries for the Supplementary Fund. So as concerns these two conventions, these are the two main features. First of all, the objective, strict liability of the ship owner is the idea is that when there is an accident, when it occurs, the liability falls to the ship owner. And then with respect to other stakeholders which may or may not be involved or be the cause of the accident beginning, if the accident takes place due to a collision, for example. But the idea is to ensure the speediest possible payment. Now, depending on the size of the vessel and its gross tonnage, there's a limit on the insurance. And then there are some aspects to the liability, for example, terrorist acts, which won't necessarily be covered. So if I move forward more quickly, when there's damage which exceeds the shipowner's liability, in accordance with the 1992 COC, when the shipowner is financially, it's impossible for the shipowner to financially meet their obligations. And if the shipowner does not have any liability under the 1992 COC, there are exceptions. They're quite rare, but they exist. In this case, the IOPC has special drawing rights of to the tune of 203 million euros, SDRs. And the exceptions, in fact, are quite limited. Damage resulting from an act of war, damage caused by a state ship, and when the claimant can't prove that the damage, in fact, resulted from the incident. You could have an incident with the involvement potentially of a tanker ship, but not necessarily provable, not necessarily with evidence. The third tier, the third level, involves the Supplementary Fund. Now, this pays an additional amount of money, but you have to be clear that it was granted in or created in 2003 following the Erika and Prestige incidents. So that's when they realized that the amounts available under the international system weren't necessarily sufficient. So that was the idea, to raise the maximum compensation. We're talking about $1 billion. And as we said, although some smaller states which don't have any oil receivers, they're deemed to be received in each state party. The limits to the compensation is simply to show you in light gray. You see what comes from the COC convention, and you see that the size of the vessel is going to determine its coverage, and you can see it can go up to some 400,000 tons gross registered tonnage. And here you see the available amounts for the fund convention are the same though. And in yellow, the supplementary fund protocol, where again, it depends on the size of the vessel. So in these conventions, this is not the full article of the convention, but this is the principal message of it. It says that compensation for the impairment of the environment, other than loss of profit from such impairment, shall be limited to cost of reasonable measures of reinstatement actually undertaken or to be undertaken. So that means that not just the lack of earnings or loss of earnings, but are concerned, but the pollution damage due to pollution, in fact, takes into account all types of damage incurred by the environment, whether it be economic or of impairment. If we're talking about damage to the environment that has economic consequences, for example, closure of fisheries, that's one thing, but and you could have reinstatement measures for the environment, but the angle applied there would be more economically oriented. And with respect to reimbursement of cost, in fact, due to cost of preventive measures or further loss of damage have to be reimbursed as quickly as possible. Here you see the types of claims. Use these little drawings so that things would be clear. You have cost of cleanup preventive measures and economic losses to fishermen or those working in mariculture. Those are, in fact, that's economic damage, and the damages to be covered are economic in nature. You have property damage and economic losses, same thing for tourism. And then we look at the cost of reinstatement to the environment. The only point which doesn't really tie into the environment is property damage. Well, there you could have something damaged by the pollution and which needs to be repaired, but these are more objects or property. So if that's clear, if we move on to the admissibility of claims, you have three types of environmental damage, three criteria. First is economic loss as a consequence of impairment of the environment. And this could be for an environment that uses the environment, that makes use of it, like fisheries or recreational activities at sea. How can you recover the economic loss? There. As an economist or those working in it will give a figure. Then as concerns the best chances of recovery, it means that you need to ensure post or enact post-spill studies, and that's a cost as well. And then you finally have the cost of reinstatement measures. Now, sometimes These are to be paid directly because it's very clear what has to be done physically to reinstate the environment. So one is more economic, and the other two are more aimed at providing the best possible reinstatement of the environment. General principles that seem pretty obvious, perhaps. You say it's not enough for a spill to occur for you to receive compensation, that expenses, loss, or damage have to be incurred. This is true of any form of insurance policy. Then the next point is that the measures enacted have to be reasonable. If there are 15 kilos of seaweed that are covered in oil, you're not going to send a semi-articulated lorry to pick them up. And then there must be a sufficient link of causation between loss or damage and the pollution. If you have environmental damage and there's an area, a tourist resort, for example, a 2 hours drive away, who feel that people aren't going to come there because of the pollution, well, the distance makes a difference. And you have to prove that there's a link. It's logical, it's rational, you have to prove it. And that means providing lots of documentation to prove your loss, because we know there's always a risk of people who are going to try and take advantage of the situation and try and obtain some of the monies to that they don't really correspond to losses for them. I've lost all track of time. He said, in terms again of admissibility for claims, there's for economic losses, lack of earnings or loss of earnings. There are two possibilities here. One is that the claimant has property which has been contaminated or proved. If you're a fisherman and your fishing nets have been damaged, sorry, I'm searching for my words again in French, but you need the tools you need. So you either have what we call pure economic loss, for example, equipment which has been polluted and which prevents a fisherman, for example, to go to sea. So that falls amongst the possibilities of filing a claim. Likewise, when your facility or your equipment or the site where you are, where your company is, has to close. That can be the case for fisheries and for tourism. I won't go into detail, it would take me too much time, but these are the two sectors where the most experience has been gained and gleaned. And there are other subjects, other areas or potential claimants like marine reserves and nature parks. Or it could be a city or a village. You could say no one's coming, no tourists are coming, no visitors are coming. We have a loss. loss of earnings, economic loss, and that could give rise to compensation. The post-claim damages or post-incident damages is when you have, sometimes by chance, the possibility of, when you have the possibility of showing that there's a direct link to the damage from pollution, that's a lot more reliable, excuse me, than if you have just, if you just indicate that it's probably due to this. So you have to provide the information, and studies very often on a regional level, in fact, can be provided whether or not the study indicates that action should be taken or that nothing should be done. And this has to be in proportion to the extent of contamination, likely effects, etc. And this sort of study is generally well received and accepted by the courts, particularly those which are specialized in this sector. You also could have an individual who can prove what needs to be done for the environment and could obtain financing for it if it's convincing. So you mentioned earlier about when you compare what happened with one accident and then one later, things are evolving, and the jurisprudence for compensation is evolving all the time too, and seeing which criteria are admissible and acceptable, that too has changed over time.
So again, on post-spill studies, certain studies can be very long, which is possible. It's possible to implement long studies if it appears to be relevant. The importance of consulting the IOPC funds and insurers is something that's particularly key in order to implement actions and to draw upon our experience, and in order to prevent subsequent conflict. So it's important that cooperation with us as funders is implemented from the outset to prevent conflict in terms of interpretation or conclusions. So in terms of reinstatement measures, so when we have a site that's damaged, how can it be returned to its pre-spill state? Here I've given some photos of what it looked like before and after. It would have been good if we'd had a pre-spill picture as well. But here you have a picture with the pollution and a picture after cleanup. So we know what it was like before the incident, and is it possible to restore it to its original condition in terms of vegetation, for example. So it's important to identify what is possible. So different types of actions can be implemented, of course, according to the circumstances. Sometimes they're classified as spill response actions, sometimes as environmental activities, but it's the same money, whatever happens. So it's a total sum of money. So sometimes there are different points of view about what the money should be used for. But the overall aim will be to minimize the overall impact on the environment. Some examples, for example, replanting mangroves or replenishing sand on beaches. So, for example, if sand has been removed to be treated off-site, then sand might be brought in to replace that sand. So we'll not go into debates about what the right technique is. That such technique can be an appropriate technique in given circumstances. Peter Taylor mentioned earlier the NEBA technique, and that can be a useful element in demonstrating the efficiency of operations and to justify operations and to justify compensation for those measures or practices that have been recognized by the industry. So those are just some examples of situations for restoration. Again, in terms of criteria for admissibility, admissible claims are measures that aim at enhancing the recovery of the damaged component of the environment. There have been situations and cases in which we receive claims, and once the money has been paid out, it's not actually used for what it was initially claimed for. So that's the kind of situation that needs to be avoided. The claims must focus on measures to accelerate the natural process of recovery. They mustn't, of course, result in degradation of other habitats or adverse consequences on other natural resources or economic resources. There's also a question of the limitation in the length of time and the overall cost. So, for example, determining the results after 3 months, 6 months, and then possibly defining new operations after that time. We don't necessarily need to agree on solutions that are set in stone for a long period of time. I definitely won't go into a lot of detail about wildlife, having listened to the previous presentation. I definitely wouldn't be able to answer all your questions, but wildlife is an important aspect, of course. In France, there have been numerous cases in which wildlife impact has been very high and very visible. As we've seen, and here we have some very high numbers that are quite powerful. There are solutions that might not necessarily be efficient. There's also the question of comparison between one species and another, one individual and another. For some species, rehabilitation is quite straightforward. For others, it's far more complex. So there's a question of choices that need to be made and need to be discussed. So here it's just an example, not to talk about costs, but just some examples. So for Erica, guillemets were mentioned. So here you have the total oiled, the number collected dead, number collected alive, and number released after cleaning. Which is very low. When you compare that to, for example, the treasure incident in South Africa, the figures are quite different. Here affecting penguins, South Africa at the time wasn't a member of our conventions. So here we had 38,500 penguins captured with 18,000 released. So what's difficult in this type of situation is explaining how to evaluate the damages and the cost per individual. Sometimes solutions which are not necessarily really straightforward need to be used. So as it was mentioned earlier, sometimes equivalents need to be found. So for response operations and economic losses, it's always difficult to provide evidence of everything, whereas wildlife is complex, is a complex part of environmental damages. And so it's not always simple to find solutions. I think we're nearing the end. In terms of non-admissible claims, to give a few examples, the most important is loss of amenities or disturbance, but without financial loss. For example, people who like to have a walk on the beach in the morning to revitalize themselves. It doesn't. It's not something that can be claimed for. So as a pedestrian, the fact that you can't access a beach doesn't entitle you to any compensation. So because there's no justifiable financial loss, it's just an inconvenience, a personal inconvenience. So instead of going for a walk on the beach, you'll need to do something else for a while, but it's something that doesn't fall within the scope of our conventions. Another important point is compensation claims based on theoretical calculations. So for example, might be said that if there's 10 tons of oil spilled at such and such distance from the coast, a certain amount of compensation should be awarded. So we reject such mathematical claims. Also, in terms of non-admissible claims, claims of a punitive nature. In a similar way to fines when you're driving, for example. That's not something that can be claimed for. We don't have a policing role. So that gives you an idea of non-admissible claims, although of course it's not an exhaustive list. These things are always open to discussion. An important point here is that you have 3 years to make a claim from the date of the incident or of the damage. If it's impossible, for example, a hotel that needs to compare with the following seasons, then it's important to make a request to the court, and so there's a maximum of 3 years. And just briefly over the last few slides, if you go onto our website, you'll find all these documents that can be downloaded in 3 languages, French, English, and Spanish. They explain all the different compensation systems and the claims process. And then there are some documents that are specifically for member states about the advantages of being a member of the IOPC funds, for example. Here, just to give you an overview for the period 1978 to 2021, we have been involved in 49 incidents for the 1992 fund. For the Supplementary Fund, we haven't been involved in any incidents so far. And here, if you need to, if you'd like to check out any further information, you can visit our website. There's an additional section that gives access to all our documents. So all the documents can be downloaded in that section, and also there's a separate website for the HNS convention, and also we're on social media if you like that sort of information source. So I can't physically show you the documents because I can't get my camera going, but you can see the picture here. They outline really specific situations, so I recommend, if you want more information about a specific point, then to go along to our website and download those guides. Thank you very much for your attention. We have a question about trends in terms of the number of cases having resulted in the activation of the CLC 1992 over the past years. Could you give us the trends there? In terms of numbers, over past years, it's decreasing. The number of accidents involving tankers are decreasing to almost nil, involving bunker oil. The largest incident in the history of the IOPC funds involved bunker oil, and that was 15 years ago now. There are also some smaller incidents, one in Greece and another in Korea, as well as Nigeria. There are 7 or 8 that are currently ongoing. It's difficult to say exactly how many there have been, but actually you can find that information on our website. There's a section about incidents, and it lists all the incidents, past incidents that are closed and currently ongoing incidents. We've never really developed documents with statistics over, for example, of past incidents. We haven't really focused on that. But today, it's quite rare to have oil tanker accidents activating CLC 1992. Thank you. That confirms the impression of Mr. Gente, who asked the question, so thank you. Just a remark in terms of the Bunker Convention. That's the convention that's most often activated. And we have a compensation claim manual that's to be developed, because there's been a lot of debate over what's admissible under the Bunker Convention. So this manual has been produced and has been was used as inspiration for that convention. At IMO, they've started working on the creation of a guide, a compensation claim guide for the Bunker Convention. So that should really help the situation there. Thank you very much, Thomas, for being with us today and for your presentation.